Rise. Dear honors, the Honorable President of the Caribbean Court of Justice and the other judges of the Caribbean Court of Justice,
The Caribbean Court of Justice, Appellate Jurisdiction. Hearing of appeal in the matter BBCR2023-001 between James Ricardo Alexander Fields and the state. The members of the panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Witt, the Honorable Mr. Justice Anderson, the Honorable Mr. Justice Barrow, and the Honorable Mr. Justice Burgess. Counsel, you may now enter your appearances.
This is this Honorable Court. I'm Andrew Pilgrim, and with me are my learned friends, Mr. Marty Garnes and Mrs. Leslie Cargill-Straker. We are for the applicant appellant.
Mr. Watson, are you hearing us?
Yes, good morning, Your Honors. I am Neville Watson. I continue to appear for the respondent state in this matter, and with me is my learned friend, Mr. Rudolph Burnett.
Yes, well, thank you very much, and good morning, everyone. Mr. Pilgrim, are you ready?
Morning, my lads, Your Honors. I am honored to be here in person, and this is not in any way to detract from the position of my friends on the other side, but it's just good to be in a real courtroom, talking to real people up close, something that has become less and less popular in this period. Your Honors, I know that you will have read our submissions and that you're familiar with where we're going, but I want to set it in a context. I think at the end of the day, we're all going to be answering this question of whether Barbados ought to be clinging to the position that has obtained for a number of decades. And to put that in context, I think it's important for us to remember the Holy Grail that was mentioned in Carlton Hall. And to say that it is far too often in Barbados that we find ourselves in a position wondering about guilt after verdict. That is to say, the absence of science and of technology in terms of the evidence that is used to convict people in Barbados, and perhaps more, it may be evident in other islands, but one has to feel in the context of Barbados, looking back also at cases like Haynes and Edwards, that this reliance on the credibility quite often of professional witnesses, but witnesses in general, as the sole plank or the fundamental plank is something that we regard as dangerous. The alarming rate at which we seem to be saying after a conviction, well, who did you believe and why did you believe them? And that being the central area makes the importance of the direction that we call into question here today critical for us. It is not sufficient for us to say, oh, well, it's been there for so long, we've been relying on it for so long, obviously. But we just urge the court to be cognizant of the fact that almost every case that we bring to your honorable court is brought with a background in which there is no support in the sense of science, technology, use of cameras, use of DNA, use of any of these things. No, again, in terms of, so that, I say that just to say how important we think this direction is. And this is why we have relied on it so heavily over the years. And indeed, in the context that quite often, maybe more so in other cases than this particular one, it's just a question if the jury are going to believe the police or not. And against that background, we have found ourselves relying very heavily on anything that assists us in showing that the credibility is flawed. Passing then to the decision of our Court of Appeal in this matter. If I look at how the state has responded to our submissions, it seems to me that they agree with us that the Court of Appeal made certain assumptions or asked us to make certain assumptions about what the judge was saying. But the state has abandoned that position, if I understand their submissions correctly. That is, they're not seeking to say that the Court of Appeal ruled against the direction. They are saying that the Court of Appeal said that the judge meant something else. The judge was talking about inconsistencies. He was not talking about witnesses who are deliberately lying. This is my reading of their submission, which brings me to the point that I understand them to be in agreement with us on that. They are, however, saying, as I understand them, that it is only in Barbados that this is happening. Everywhere else, something else is happening, and therefore Barbados is wrong. Let us get it right. This is my loose interpretation of what my friends are submitting. They have not made any attempt to defend the Court of Appeal position as I understand it. That is, they agree with me that the Court of Appeal's decision that I should have identified for the Court of Appeal a particular lie as told by a particular witness, and the Court of Appeal decision that the judge did not mean to speak about deliberate lies. He meant to speak about inconsistencies. They are abandoning those positions. So that, in my humble view, we begin from a position where we are all agreed that the Court of Appeal was wrong for whatever reason, whether for the reasons I say or for the reasons that the state is saying. The Court of Appeal is wrong.
Mr. Pilgrim, let's cut to the chase.
Certainly, sir.
As I understand it, your submission is that following Canterbury, and perhaps because of Canterbury, there is a rule of law in Barbados that if a witness is found by the jury to be deliberately lying, then you must discard everything that witness says. Is that your submission?
My lord, yes. But for the fact that I will say that it existed before Scantlebury, one, and that, two, this is a position that I don't think the state can resist. This is the standard direction given in Barbados every day up to yesterday.
Okay, fine. Well, let's examine that standard direction for a moment. In the first place, the premise. If the jury finds that a witness is deliberately lying, who determines and how will that person determine that the jury has found that a witness is deliberately lying?
In which context, Your Honor?
Well, the premise
Here now?
is if a witness is found by the jury to be deliberately lying, how does one determine that the jury has found that a witness is deliberately lying?
Well, it's very difficult, Your Honor.
It's impossible, because unless the witness concedes, admits, I am lying,
Yes, Your Honor.
I don't know forensically how else it is possible. The jury doesn't give a written judgment,
No, Your Honor.
and it's not permissible to be interrogating them. So there's a problem with the premise of the submission.
Of the direction or the submission, Your Honor?
Well, both. because the submission seems to be relying on, well, not the direction, on the case law on which the submission is based. The second aspect of it, which is of concern, is how does this case law, how does this submission relate, for example, to a Lucas direction? A Lucas direction, as I understand it, is one where a judge is required to sit to the jury. If you find that a witness is lying, then you can't use that evidence without looking at other things. Am I correct?
Essentially, yes, Your Honor.
So how does this submission and this case law relate to, are we throwing out Lucas as well?
Your Honor, the challenge is that Lucas, quite frankly, doesn't come up in our jurisdiction the way that this direction does. So that I'm not saying that we have effectively abandoned Lucas. I don't think I can go that far. But the reliance on this direction is, is widespread. You know how else to put it.
But Mr. Pilgrim, even if that is so, the question is, as I understand it, the principle, the rationale for the Lucas direction continues to obtain in Barbados. It has not been discredited. It has not been treated as overtaken by new jurisprudence, etc. So the principle, the premise of the Lucas direction continues to obtain.
Your Honor, the only answer I can give to that essentially is that Lucas, when used in Barbados, is often used in the context of the accused, and often used to say, so that it's applied as one standard for the accused, and that protects him from a jury making a finding that he has lied on one point, but he can still be innocent.
Right. And he can still be believed on the other point. So I lied about in my alibi defense, but
Doesn't mean I committed
does
the crime.
not mean, right.
Essentially, Your Honor. So Lucas, sorry.
Is to the third issue, which is that this rule of law, it only applies to prosecution witnesses. So only if and when prosecution witnesses are found to be deliberately lying, you throw out all the evidence. But defense witnesses can lie as much as they like.
No, Your Honor. I don't think there's any reason to say it doesn't apply to defense witnesses. I don't think there's anything in what we've submitted that suggests it doesn't
So
apply
it applies across the board.
across the board to
No,
everyone.
but what you're saying, as I understand it, is that it doesn't apply to the accused,
I think that's correct.
because there's a difference between ascertainment of credibility and ascertainment of guilt.
Of guilt. So that in the context of the accused man, the jury looking at him are always asking themselves two questions.
Yes.
Not just do we believe him, but did he do it? And Lucas protects him.
Yes.
And that we say is different to the protection that we say this provides, but which extends to both sides. We're not saying that it refers only to prosecution witnesses. We're saying that if someone picks up the Bible and so on and swears in front of everyone in the jury, that the level of scrutiny attached to them becomes more significant.
So, Mr. Pilgrim, two questions. First of all, the Scantlebury direction. How established is that in Barbadian law?
Your Honor, to say that it is the direction being given every single day by every single judge,
No, I'm
except
talking
this
about
one.
I'm talking about the Court of Appeal. I mean, the Court of Appeal's approach to that direction. Do we find it encrusted in the jurisprudence in Barbados, or is it applied sometimes and not
applied across the board, Your
the Court
by
of
the
Appeal?
Court of Appeal.
So the Court of Appeal in this case, was it by inference establishing a new standard and disagreeing with Scantlebury?
Your Honor, in my view, no. It seems like our Court of Appeal was saying this is not a case necessarily of the judge talking about a deliberate liar. This is a case of the judge making not being entirely accurate, and it may be that, not it may be, they're saying he was referring to inconsistencies and not to deliberate lies.
Because the last question, Mr. President? Yeah, the last question which I wanted to raise with you is this. Are we confronted with an issue in the end of stare decisis, and whether a court of appeal can refuse, in Barbados, a court of appeal can refuse to follow the precedents of earlier courts of appeal?
In our view, they're bound by the decision unless there are circumstances that warrant them leaving it.
But the question is this at the bottom? Sorry, is this question of stare decisis at the bottom of what is being urged by the other side and what you're resisting?
Sorry, Your Honor. Is it what they are urging?
Yes.
Yeah.
They are urging that a different direction should be given.
Yes, Your Honor.
You're saying that the Court of Appeal did not follow the decision which is encrusted, as it were, in the jurisprudence in Barbados.
Yes, Your Honor.
Seems to me that the question would then be raised, must be raised, in what circumstances can the Court of Appeal depart from earlier decisions of the Court of Appeal? That seems to me to be really at the heart of everything here.
Or is another way of looking at the same question, whether this court should overrule the direction in Canterbury so as to give fresh direction to how directions ought to be given in Barbados. Is that not another way of looking at it?
Well, Your Honor, I think this court will have to make a determination as to whether they view, first of all, whether the Court of Appeal was right or wrong,
Yes.
whether they were overruling themselves without the authority so to do.
That
And I
is
suppose
part
at the end
of-
of the day,
Sorry, that's part of the difficulty I must say I had with a lot of your submissions, Mr. Pilgrim, because I think you gave us 5 grounds on your for your appeal, and 4 of the 5 grounds, the first 4, seem to be premised on the notion that this Canterbury direction is good law, and that the Court of Appeal somehow confused, mixed it up, attributed wrong motives to the trial judge, etc., etc., which you may or may not be correct on. But we, I think, gave you special leave to argue quite a different issue. And that different issue was whether this Canterbury direction was, in fact, good law. Because remember, the idea was we gave you leave for us to consider argument as to whether there was a doubtful precedent that would be left on the record unless that doubtful precedent was corrected.
yes, Your Honor, we still cling to
So
that.
that all of the arguments that you have put forward to do with whether the Court of Appeal was acting consistent with this Canterbury direction, whether they applied the mystery rule to what the trial judge said, with respect, I don't think get us that far. I mean, the critical question, if I may be so bold as to adopt the line of questioning raised by the President, has to do with the bona fides, the validity of this Canterbury direction. And the fact that the direction has been followed and celebrated, as you say, does not necessarily mean that it is valid, surely. Surely the validity of the direction must be located on other grounds, not the fact that it has been followed, because we have had lots of laws followed and then overturned. So the question then is, well, what are the grounds that you put forward as indicative of the validity, the continuing validity of the Scantlebury direction.
Well, perhaps we could inquire in the alternative. What reason is there to say that it is bad in the context?
Who are the one pursuing an appeal, surely?
Oh, indeed,
Yes.
Your Honor.
There are many reasons to say it is bad. I looked at Scantlebury again this morning, and I see it was, happily for you, a case where in one or two sentences, Sir David accepted your submission. I did not see that there was any advertence to any history, to any jurisprudence in relation to the principle that you espouse. It was simply one or two sentences of acceptance in paragraph 18. And therefore, with of course every respect for Sir David and his eminence and exposure to criminal law, it is not that he based himself on any compelling history or jurisprudence. And then, as indicated in the submissions from the respondent, the plethora of instances in which different courts across the common law world have gone with a direction contrary to what was stated, what was accepted in Scantlebury, I think are very cogent reasons to find that the Scantlebury direction is not tenable or is to be re-examined because it goes against the flow of authority.
Your Honor, there's two things I'd like to say in response to that. One is that I would hardly like to give the impression that I led the great Sir David Simmons to a decision simply by getting up and jumping up and saying this is what we should be doing. I can't emphasize enough that this is perhaps taken for granted in Barbados because this is the way the directions have been given from time immemorial.
Well, not quite from time immemorial. I mean, you cited 18 cases.
Yes, sir.
And we have been through those 18 cases. And the first time that this issue came up, I believe, was in the case of 1968 that you cited. So it's
Sorry,
not
sir?
time immemorial, at least not from my point of view. I was a little boy in 1968, but I still remember 1968 quite well. So it's not from time immemorial. There is a case that was cited in the 1968 case, Harris against R. That was 1927, not
Yes.
a Barbadian case. And that was the first time that my research indicates that a direction was given which was close to, not identical with, but close to the Scantlebury direction. So if you look at the etymology of the rule, I would like you to indicate to us, well, where did this come from? Because it certainly didn't come from Scantlebury, as you said. Scantlebury relied on what you put before, say, David, and I guess you relied on what came before you.
Yes, sir.
So, but where is the origin of this rule, and what is the justification for it?
In my humble view, Your Honor, the justification for it is the preponderance of reliance on professional witnesses who can be vulnerable, who are liable to do the things that we complained of in Haynes and Edwards, who are liable to do things that will require severe scrutiny. But it is not for me to, I was replying to your learned brother to say that I didn't just pull this out of the air. This is something that the Court of Appeal has been ruling on, and yes, in 1969, they indicate that the basis is a 1927 decision.
Yes,
But
if you look at the 1927 decision, it is not in any way similar to the Scantlebury direction. It's very different.
it certainly goes further than where my friend is asking us to go.
Yes.
So that the challenge is that this direction is being given, as I say, by one judge in Barbados. That doesn't make him wrong because he's one, but that one judge is giving this direction without offering any attempt to assist the jury in circumstances where they believe a witness is deliberately lying.
Could I just say one more thing about 1927?
Certainly,
This is
yeah.
the Harrison R. And that says to the effect that if you find a discrepancy and you come to the conclusion that a witness is deliberately lying, well, obviously, you will reject that witness's testimony on that point. And you will approach with greatest caution his testimony on any point, because a person who deliberately lies is not a person that you can properly accept. But notice the words, you will approach with greatest caution. Now, it seems that since 1927, in many cases in Barbados, this has gone far beyond that. And we have gone to the point where if you find a witness lying in any particular, you must throw out all the evidence of the witness. How can that possibly be the case? There is no consideration of the materiality of the lie. So let us say that somebody lies about having an affair.
Strangely, that example seems to come up all the time in the Caribbean when this is discussed.
Having an affair. And that affair has nothing to do with the crime. Nothing whatsoever.
A fellow is concealing his outside woman while seeing the actual crime committed. He can't say he was with his outside woman, so he says he was out there playing marbles with Jeffrey and Jimmy.
Now, if he lies about having an affair, and that affair has nothing to do with the crime, nothing whatsoever, he's afraid of being embarrassed in the public or whatever, that's one thing. If he lies about being at the scene of the crime and witnessing somebody killing somebody else, that's something else, surely.
Yes, Your Honor.
But this Canterbury direction makes no distinction between those two situations. There is no distinction regarding the materiality or the relevance of the lie to the charge before the court. So how could this Canterbury direction in its broadest sense be defensible?
The challenge, Your Honor, is that we will never know what the fellow is lying about. If the jury make up their mind that he's lying, and they decide to treat him in a particular way pursuant to the direction.
This is precisely the reason why this rule is so fraught. Because where the trial is bifurcated, you have the jury trying fact, who don't give any written decision. You must say to the jury that you are the trial, that you are the ones who must assess credibility. If you have a rule of law that says you must tell the jury that, but you must also tell them that if they believe a witness is lying in one particular, you must throw out all their evidence. Those two things collide with one another violently. Because it seems to me that if at the stage of the end of the prosecution's case, if Canterbury is good law, then the judge should say to the jury there and then, well, don't rely on X's evidence, because X has been found to be deliberately lying in one particular. Why are you putting X's evidence to the jury if the judge at the halfway stage has determined whether by the witness conceding that he has lied or by it being patently obvious on the basis of the cross-examination that the witness has lied? Why are you still putting that evidence to the jury? And then when the jury convicts because they make up their minds on what they believe, you facilitate an appeal?
Well, Your Honor.
Sorry, Mr. Pilgrim, while you're contemplating, while you're contemplating the answer to President, Honorable President, I raised the question with you a little earlier as to whether there is a body of precedent for Scantlebury in Barbadian law. I've looked through the authorities which you have submitted and other authorities, and it seems to me as though there's that body of law.
Sorry, it seems as though there is.
It's a body of precedent which justify quite apart from the logic of Scantlebury, the body of precedent justify Scantlebury decision or direction.
Yes, Your Honor.
Isn't that certain? Isn't that certain law in Barbados? Is there any doubt? Was there any doubt before this decision that that is what is the law in Barbados? Because it seems to me that if a legal system is going to benefit from the doctrine of stare decisis and the certainty which comes with it, that a court, okay, the Court of Appeal, if we can talk in terms of horizontal stare decisis, the Court of Appeal has to follow the Court of Appeal in criminal decisions. So this is why I'm raising the question with you. I'm trying to get some idea of how well settled was the Scantlebury decision before the Court of Appeal, in this case, didn't follow the Scantlebury decision. I don't know if you understand the question I'm raising with you. I know it has a lot of moving parts.
I think the challenge is, I think we can all virtually agree that there was no doubt as to what the settled position was. The question is whether, as the President is asking, as I understand him, ought we not to put the judge in a position to weed out the liars? But obviously that would be a complete usurpation. If the Scantlebury direction stands as it is, it still remains a test that the jury are applying. It still remains the jury making up their minds about whether a person is taking the oath and deliberately lying to them or no.
So you then have the freedom, you meaning a defense attorney, to say to the jury, well, look, if you find this witness is lying in any particular at all, you must disregard everything he has said.
That's right. I do.
And that license is not limited to the materiality of the lie. You can look in the witness in the eyes and say, if you find that the jury, if you find the witness has been lying in any particular whatsoever, then you must disregard everything that he has said.
That's correct, Your Honor. Your Honor, this is why I wanted to start so much with context, and I understand the court's concern perfectly well. But in practice, that lie is typically, did you beat this suspect? Did you?
Sorry, with respect,
Yes, Your Honor.
in carving a rule of law that will be guiding the affairs of the judiciary, we cannot, of course, restrict ourselves to the most extreme example that you're going to give us.
But it's not the most extreme. This is why I say the context is that it is a widespread situation which we sought to address. This court addressed to some extent in cases like Haynes and Edwards. We've now put in place statutes that will eventually protect us from confessions that are exacted by other means, because now we are obliged to record. But as the court will appreciate, in the context of Barbados, the trials I'm doing now are about law that existed 10 years ago and before. So all of the trials that I'm doing now, there's no recording of confessions. There's nothing of that kind.
But with respect, Mr. Pilgrim, this has nothing to do with that, does it? I mean, this has to do with an ordinary witness who has come forward. He's not a police officer. He's not connected to law enforcement. He says, I have witnessed this particular incident. Your client shot the deceased and fled. And the question then is, can you properly face the jury and say about that witness, if you find that he has lied in any particular, you must disregard everything that he has said to you in evidence. That is the issue.
Well, the context in this case was that witness was a known drunkard whose nickname was Drunkard, who went into the police station in a state that apparently suggested he was living up to his name. So the context there was...
If then he was found to be lying, in relation to what he told the police was his nickname, I gather that was an issue in the case. That's whether he was it ASC Fields or something like that?
Yeah.
AS
Yes,
Fields.
yes,
Okay.
Fields.
So let us say, for argument's sake, that he is found by the jury, to be lying on what he stated his name was to the police. So you're saying that because he lied on the oath as to what his nickname was to the police, the jury must disregard everything he said about being there, seeing your client, pulling a gun from his waist, shooting the deceased dead, and fleeing the scene. Is that what you're saying?
It's what the law is saying, Your Honor. It's not what I'm saying.
Okay, so that's what we have to decide, if that's good law.
Your Honors, I think it must be clear that, quite apart from the fact that I form no role in this trial whatsoever, I am fighting for a principle which I still regard as being extremely important. And even if this court were to form the view that the laws of Barbados are errant and rogue and need to be cut down, I'm urging the court to find that the approach of the learned trial judge in this matter is such that he is not making any attempt to protect the jury from widespread deliberate lying. So that
Was there no case submission made in this case? I believe so.
I believe, yes, Your Honor, there was.
So, but you're not complaining that the judge wrongly sent the matter on to the jury?
No, Your Honor.
But if there's no complaint about that, then how can there be a complaint about the jury assessing the credibility of the witnesses in the case?
Sorry,
But
Mr.
credibility is a matter for the jury, so the no case, I'm not sure if I follow the no case point, Your Honor.
No. If evidence is given that is so tenuous or so, you know Galbraith better than I do, so battered by cross-examination that it does not support the case of the prosecution, then the judge must stop the case.
Yes, Your Honor.
That's Galbraith.
Yes, Your Honor.
If the judge did not consider that the evidence form part was of that ilk, and the judge overruled the no case submission,
Yes, Your Honor.
then you are asking that, you're suggesting that a rule of law exists that notwithstanding that,
Am I suggesting that, Your Honor?
well, that's your submission.
Yeah, but it's the law, sir.
Well, the law seems, the case on which you are basing your submission is suggesting that notwithstanding that, the jury are still hobbled in assessing credibility. Because if they find that a witness was lying in one particular, irrespective, as my brother says, of the materiality of that particular, they must throw out all the evidence of the witness. Even though the judge has already determined at the no case submission stage that this evidence should go to the jury. Isn't there a clash between those two things?
And while you're pondering that question, Mr. Pilgrim, was it open to Justice Greaves to not to follow Scantlebury? Was it open to him to formulate a new rule?
No, Your Honor. Not in my view. But Your Honor, it's 2 points. If this honorable court sees that as a direct clash between the role of the judge and the role of the jury, this direction and its existence, and would mean a usurpation and so on and so forth, would the court not still agree with me that situations in which a person is deliberately lying on oath require some attention from the learned trial judge?
But of
Above
course,
and not
and
necessarily.
Every trial judge gives that attention. They give a direction on how you deal with discrepancies and inconsistencies. And this judge did it in this case.
It's not as, it is, in our humble view, it's not a simple discrepancy. It's a situation akin to the 1927 position. If you see a person as being someone that will come to court and pick up a Bible and swear in front of a jury and say lies, you have to at least offer them more scrutiny than a person who's making a mistake.
Nobody denies
Absolutely.
that. Nobody denies that, Mr. Pilgrim. Everybody agrees with that. And the fact is that
But except the learned trial judge, Your Honor.
1927, well, we can do something about that. 1927 says you should approach the rest of the evidence with caution.
Yes, Your Honor.
So I think that that is going some way towards your concern. My brother, Justice Burgess, though, I thought was leading you in a different direction. He can correct me if I'm wrong. But I thought he was suggesting that given the solidity of the law in Barbados and given the role of precedent, the question is whether this court, if it was so minded, should in fact overrule this Canterbury direction. In other words, what are the standards? What are the criteria which this court should develop, assuming it has not yet done so, to decide to overrule a rule of long standing in the jurisdiction of Barbados? I'm not sure that you have responded to my brother. Thanks.
Your Honors, we offered the case of Kirkpatrick as a guideline approach to say that if a court of appeal, first of all, is going to depart from its position, that there are some criteria they should look into. Whether this decision was given per incuriam, whether essentially the law has fallen into such, sorry, that's it. The quote is, the decision rationale has been eroded by significant societal or legal change, which they call foundational erosion, and whether the decision has proven unworkable, or the unworkability test. And we submit that those don't apply here.
Citation with us, do we?
Kirkpatrick against the Queen, and this was part of our late submissions, Your Honor.
Maybe it came
And
in too
it's-
late for me to see.
Sorry, Your Honor.
Maybe it came in too late for me to see, Counsel. I'm not sure I've seen it. Kirkpatrick against
It's 2022, 5 LRC at page 387.
2022 5 LRC
387.
387. Thank you.
What does that decision say in summary?
In summary, my lord, that if the Court of Appeal is going to depart, try to bring it up on the camera. I'll read it because it's quite brief.
If I may quickly,
Certainly, Your Honor.
that's not that is not what the case decides. That was a dissenting, three dissenting judgments, judges. So you shouldn't present it to us as though this was the decision of the court.
We're not saying it's the decision of the court, we're saying it's guidance on this point.
Okay, yes, and I hope that you can give this court some guidance on how we should approach Kirkpatrick.
But Your Honor, sorry.
If I understand as well, these are rules that will count for a court of appeal, whether they will change the route,
Their
so
own
to
decision.
speak. But that wouldn't be rules concerning at the higher court, correct?
Certainly, Your Honor. I
Yes,
think-
and that is what actually interests me even more, although it's an interesting side point maybe. But, you know, I think you started out by saying, well, you gave the context. As I understand this, theoretically it might be a rule, the Canterbury rule, if you want to call it that way. Theoretically, that might be a difficult thing to maintain from a doctrinal point of view. But you look at the background in a more practical way. And we all know, this is for Barbados, not only for Barbados, you have two difficulties here. You have usually very, what shall we say, minimalistic police investigations. On the other hand, you have a jury, which is a black box, which you simply cannot know what they decide, why they decide things, etc. There are no reasons. And so this might be an overreach in a way, theoretically speaking. This is how I understand you.
Yes, sir.
But you know, it's a rule that you use not to counteract against all these uncertainties and all these lacunae which you usually have in police investigations, etc. So that is how I understand your point that we should not overturn this rule.
Yes,
from-
Your Honor.
Is that more or less well understood?
That's a reasonable encapsulation, Your Honor.
Okay, well, whether that will hold or not, that's of course
There's
a
another
que-
point in
That's
there.
another point, but I just want to understand what you are trying to make clear to us.
Yes, Your Honor. I think that my point is simply that Scantlebury is not something one that Andrew Pilgrim pulled out of his pocket one day before Sir David Simmons. That's the point. This is something that exists and developed in Barbados in a context of fighting against bare bones prosecutions, as described by this court. And that if we are to reach the Holy Grail, we can reach there by one of two means. We can reach there by introducing the type of prosecutions that we all want to see, which show multi-tiered levels of evidence put before the court. Or we can get there by putting directions in place that allow a jury not to leave the deliberation process unguided whatsoever as to how to treat people who they believe are lying to them.
That you, sorry, what are the paragraphs in Kirkpatrick that
It's
you
at
would like
page
us to look at?
445, Your Honor, and it's paragraph 202, below a caption, the three circumstances in which overturning precedent may be warranted.
Mr. Pilgrim may suggest that it begins at paragraph 178.
Yeah. Sorry, Your Honor.
May suggest that it begins at paragraph 178. The point is that this court you've confronted this court with a duty to not to overrule, but this court has to have a basis for overruling or not overruling, because the system of stare decisis which exists procures certainty in the jurisdiction. And I think that certainty is the principle which this court has to be aware of. And if this court is going to overrule precedents, then it's not only a precedent, but precedents which have existed from time immemorial, I would suggest that this court should do so in a principled way. So that I am a bit I'm waiting still for you to explain that very useful decision in Kirkpatrick, and which was foreshadowed in Haywood, a Barbadian Court of Appeal decision. So that, as far as I'm concerned, I think that this court should be assisted in the kinds of principles that it should be aware of and observe when it is going to take a decision to overrule or not to overrule. Because this is not peculiar to this case. It could arise in the future. And what I suggest is that you may want to help this court in that direction.
But we talk about overruling and overruling. Is it the same thing if the Court of Appeal overrules itself as if the apex court overrules the Court of Appeal?
It is not the same thing, Your Honor.
And the same principles don't apply?
I think the short answer to that is no.
The
Yes.
apex court overrules the Court of Appeal all the time,
Yes,
from time to time.
But I think it's not something that they do lightly or something that they do without
Exactly.
showing the good reasons for departing.
Well, of course.
Well, I think that's the point my brother Burgess is getting at. So even if the Kirkpatrick rules criteria are not applicable, surely this court must act on principle in deciding to move the law away from what it is now in Barbados. But the question is, well, what are those principles? And I speak subject to the President's greater experience here, but I'm not sure that this court has yet established what those principles are. And we are looking to you to assist us in identifying what those principles could be.
On the other hand, as I understand it, is you want to keep the rule. You don't want to have, you don't want us to overturn it.
Your Honor, I think that's the point. I think the court is asking me to help it to, I nearly use a term that my father would use, to cut my own tail.
No, sorry, your tail is not in any danger of being cut here, I assure you. The point is that you have a duty to assist the court, one.
Yes, Your Honor.
Secondly, you have agreed, so I took it, that the materiality of the lie is important, so that you are agreed that there are certain circumstances where the court gives a direction in relation to a witness that may be found to be lying, and that in one view, this Canterbury direction may go too far because it doesn't distinguish between materiality of the lie. So in those circumstances, we're asking you to assist us in deciding on, well, what are the principles that should guide us in deciding on a departure, or maybe not, from this Canterbury direction. It has nothing to do with cutting your tail, Mr. Pilgrim.
Your Honor, the challenge that I face is that I'm not in possession of authority that gives a direct basis on which you should depart from the position of the Court of Appeal. But I think it is accepted in principle that you can.
We know that you are very nimble on your feet, Mr. Pilgrim.
Well,
But it would seem to me that maybe the other side is the one who wants to change the rule. So if we hear from them, you might be better equipped to react to those arguments. Is that so?
I suspect so, Your Honor.
Yes,
Your Honor. Other than that, I think I am celebrating things I don't wish to celebrate. And while I'm not necessarily having my tail cut, I am certainly offering the belt up to the cutter.
Prepare then to accept what the other side says, because you have the first shot at it. You can give us some indication as to where you think we should go. Or are you willing to throw your hands up and say, well, let the other side go first?
Your Honor, I think I have to respond to them on that point. That would be their point. My point is, don't overrule it. If they're saying overrule it, they'll say why and how. And if I disagree, I will reserve the right, presumably, to be heard on the point.
Thank you.
Sir.
So if I could summarize your submission, you say the direction that was proposed in Canterbury is good law. It has been followed for a considerable length of time, and there is good reason for it.
Yes, Your Honor.
Because of what my friend likes to call the minimalistic way in which investigations are carried out and the need to protect accused persons. That's essentially your submission.
That's essentially it, Your Honor.
Yeah, well, I don't know that there's much more that you could usefully tell us
I don't
until
believe
we
there
hear
is.
from the other side.
I'm obliged, Your Honor.
Yeah. Thank you. Mr. Watson?
Yes, Your Honor. Good morning again.
Yes, Mr. Watson, we're hearing you.
Oh, yeah, I'm sorry, Your Honor. Your Honors, we continue to stand by our our response to the appellant submissions, we are of the view that the direction in Scantlebury is one, sir, that should be jettisoned, should be discontinued altogether. We are of the view that to leave that direction as it is, as it stands, would be to essentially give to a trial judge that power to impermissibly enter the arena of the jury and to make determinations of questions of fact. Because we are submitting, and we continue to submit that, and this honorable court is well aware that credibility or reliability are matters which are within the exclusive competence of the jury.
I think we understand that basic point, counsel, but just to pick
Yes.
up from where the discussion with Mr. Pilgrim left off, obviously you would agree that you bear the burden of getting us to change this Canterbury direction, which has existed in Barbados for a very long time.
Yes, Your Honor.
Mr. Watson, you did this case at the trial? You prosecuted this case?
Yes, Your Honor. I prosecuted that case, sir.
Your current views on Canterbury, you have only come to those views very recently. Am I correct?
Yeah, yes, Your Lordship, Your Honor. It has only just risen, and I've only had that occasion or that opportunity of looking at it in great detail.
Because in this case, you actually suggested to the jury that that was how they should approach the evidence. Page 116, line 18, about the man.
Yes, Your Honor. Yes, Your Honor. I recall that I did address the jury in that way during my opening remarks to them. But that was certainly before I looked critically at Scantlebury and had, a different viewpoint, especially after I had taken a look at the authorities from around the globe as it relates to issues of credibility. I had a change of heart in that regard.
Sorry, Mr. Watson,
So-
sorry.
Yes, sir.
Are we still operating in a system of stare decisis where courts are bound by courts in the hierarchy? You said you saw this thing from around the world, different jurisdictions. Are our courts policy deciders, or is the doctrine of judicial precedent there for a reason? Do we just ignore judicial precedent because it is not fashionable any longer, because a precedent is not fashionable any longer?
Indeed not. We should follow judicial precedent until a higher court says we shouldn't follow it any longer. But in answer to that question, at least let me go a bit further, if you will, Your Honor. In the doctrine of stare decisis, according to VC Crabb in Understanding Statutes, he says that stare decisis doesn't seek to control, and that its importance lies in the guidance that it affords. But he also says, and I paraphrase, that its application must be opposite with justice and its use compatible with common sense. He also says that, blind adherence to precedent is fatal to the development of the law. Indeed, I am not using this to say that
Sorry, do we have that reference, Mr. Watson?
It is Understanding Statutes by V.C. Crabb, and it's at page 62 under the rubric, The Problems of Binding Authority or Precedent.
Sorry, I was asking you, did you supply that reference to the court earlier?
No, Your Honor. This morning around 3 or 4 o'clock, I couldn't sleep, and I just started reading fresh again, and I came across this morning.
Well, we appreciate your industry, Mr. Watson, but really, if you expect us to take notice of these matters, you either have to go a bit more slowly so we can take a note, or you have to send the reference in to us, surely.
I will undertake to go slowly, Your Honor, and I will also undertake to supply the note as well.
Thank you.
So if I may be allowed to repeat it.
Please.
Thank you, Your Honor. Reading from page 62, Understanding Statutes by V.C. Crabb. Stare decisis does not seek to control. Its importance lies in the guidance that it affords. It is a tool which has differential effects and differential values. Like all tools, it may be bad, blundering, or blunt. Its application must be opposite with justice, and its use compatible with common sense. Blind adherence to precedent is fatal to the development of the law.
Sorry, Mr. Watson, I get the
Yes,
impression,
Your Honor.
sorry, I get the impression that Professor Crabb was speaking about stare decisis in the context of statutory interpretation and the value of precedents in statutes, that he wasn't really discussing stare decisis in the arena of common law. Am I right in getting that impression?
I do not get that idea. Simply because the learned professor went on to say that it is always desirable to distinguish between the general principle laid down by a case, that is, the ratio decidendi, and the decision by itself. So I get the impression that cases such as this one, where case law is concerned, I get the impression that there was some reference to that as well. I'm not suggesting that there may not have been the starting point of statutory interpretation, but it seems to me, based on the reading, and this is only my view, that the common law was at play here as well.
One last question, Mr. Watson. Did you have an opportunity to read Kirkpatrick, the decision which I think counsel for the appellants submitted? Did you have an opportunity before 3 o'clock or 3 o'clock this morning to look at that decision?
Unfortunately, Your Honor, I haven't seen that case.
I had hoped that it was shared with you, because this court is tasked by you with the possibility of overruling settled law. And it seems to me, as I said before, I'm repeating myself, that this court can only do so on principles. This court, if it does not act on principle, will be castigated for acting on caprice. So I would suggest that perhaps you may not use this decision, but if you could give this court some assistance in the kinds of principles which it should follow in deciding whether to overrule precedents or not.
I query that this, Your Honor.
Mr. Burnett, counsel,
Yes, Your Honor.
it seems to me the short point as a practitioner that you may wish to take is that the higher court overrules a lower court all the time on the basis that in analyzing a precedent, it is found that it is based on a wrong principle. Yeah?
So the question is, could you explain to us why it was wrong? Why it is wrong, why Canterbury law is wrong, and we should overturn it, because that is what we're waiting for, to hear the arguments. Maybe you apply certain principles to it, but give us the arguments.
Yes, Your Honor. This Canterbury principle or this Canterbury direction is wrong simply because the case or the principle or the direction gives to a trial judge the power, the authority, and the will to judge. And this is a trial judge sitting with a jury. It gives to that trial judge the will, the power, the authority to judge the credibility of a witness. It impermissibly gives that authority to the trial judge. And Canterbury is wrong because of that principle.
Mr. Watson, I think with respect, you have made that point before, and we understand it fully. I believe my brother Burgess, though, may be asking a deeper question, which has to do with the circumstances in which precedent is overruled. Now, there are various theories which say that even though a higher court recognizes that there are difficulties with a decision, if the decision has stood for a very, very long time, that is regarded as super precedent, and which then attracts a very high threshold for its overrule. As you will recall, that is why there was such furore in the United States when Roe v. Wade was overturned recently, because it had stood for such a very long time that people thought that it was settled law, and therefore, even though there might have been doubts about it, the thinking was that it would not be overruled. Even those who are very, very conservative on the U.S. Supreme Court, they have said that there are certain things that are, Marbury and Madison being one of those, who might have thought that those were wrong decisions. But they have stood for such a long time, brought such certainty to the judicial system that it would be unwise to overrule them at this stage. So I'm afraid it's not simply a matter of whether the precedent was wrong in a technical sense. I think you have to go beyond that and demonstrate to us that it is not only wrong, but it's appropriate in the circumstances to overrule this Canterbury direction. The question is, are you prepared to do that?
Your Honor, I think that to leave Canterbury as it is would indeed lead to confusion, would indeed lead to uncertainty as far as the jury is concerned, the jury being arbiters of fact. To leave that direction in place as it is would be to oftentimes or at times take away vital evidence, even from a defendant, from an accused person. Because if we were to say to a jury exclusively, if a person lies about one material particular, discard all of the evidence, then
Not one material particular, it's one particular. As I
in one
understand it.
particular,
Yeah, so why do you say
in one
material?
particular, discard all the evidence. Then I think that a jury who comprises laypersons might very well find themselves in a position where more confusion, more chaos attends to a matter that they are judging, attends to a position where they're thinking to themselves, look, and we don't know this, they're thinking to themselves, look, well, I believe this witness on this, but I don't believe him on that. But the learned trial judge is saying to us, because he has lied, we must discard all of the evidence. I think that puts a necessary strain, a necessary burden on the jury
Mr. Watson.
to decide questions of fact. And because of that confusion, I am of the view that we require certainty. We require, we need to know that once a jury is given directions, that the jury still follow the directions, but that the jury still have a say as it relates to issues of credibility and reliability.
Mr. Watson, although it is possible that an accused will be heard as a witness, he's also an accused. So my question is that direction ever given when an accused has been heard under oath? And do the judges then say, well, if you think he lied on one point, you should discard everything he says? I understand they say that when it comes to ordinary witnesses, let me put it that way, but not when it is an accused who gives evidence under oath. Is that correct or not?
It is given across the board, and it relates to all witnesses who go in the witness box.
Across the board?
Yes, Your Honor, and it relates to all witnesses who go in the witness box.
Sorry, Mr. Watson, I know you answered the question, but your answer is such a startling one for me. I need you to say it again. You are saying that that direction is given in relation to the accused when he testifies on oath?
The direction on inconsistencies, discrepancies, or differences, or variances is given across the board.
With respect, I'm not asking that. I'm asking in relation to the deliberate lying direction. Is the direction given in relation to the accused who testifies on oath that if you find that I think you catch your point. Thanks.
No, a Lucas direction will be given in relation to the accused man, but witnesses who may come for the defense, the direction will be given in relation to those witnesses, but not to the accused man.
You were saying that if we change this direction, then it might confuse the jury. But
No, if we don't change it,
Yeah, if we change it, no, if we don't change it, it might confuse the jury, but the jury has not been confused all that time. It seems a very simple and strict rule, maybe a wrong rule, but it wouldn't confuse anyone because it simply says if you think he lies on one point, forget about the whole evidence he gives. So that is a pretty clear rule. If you say, which according to you is the better rule, well, if he lies on one point, you may think he lies about everything, but you also may think that he is talking the truth about certain other points. Then it makes it more difficult for a jury. Let's not forget, they are 12 amateurs, not used to do this kind of work. That might be more confusing. So the idea that not changing it would be confusing doesn't appeal to me, I must say.
In addition, Mr. Watson, while you're contemplating that, doesn't the Scantlebury decision accord with the datum that it's better that a guilty man go free than innocent man be whatever it says? I don't remember the exact datum, but doesn't it accord with that?
I don't think so, Your Honor.
Thank you.
I don't think so, and I don't think so for the simple reason. I don't think so for the simple reason that we give to a jury the power to judge its peers, and if we give them the power to judge its peers and say to them, "Well, you are the arbiters of fact. You decide where the truth lies. You decide reliability. You decide credibility," then to come back then and take away the power from them. You're giving on one hand, but then you're taking it back. I think that is a problem.
I wanted to ask Mr. Watson, in searching for the basis for seeking to persuade us to depart from this Canterbury direction, whether you may not find refuge in the provisions of the Constitution of Barbados. Is there anything in the Constitution that might assist you in convincing us that it is appropriate in the circumstances to depart from this Canterbury direction?
I think the whole question of fairness would apply.
Because fairness applies not just to the accused, but to the alleged victim and to the society, I assume.
Indeed, Your Honor.
Is there anything you want to point to us, any particular place in the Constitution where that finds refuge?
Yeah, 8.2.
Yeah, what provision? Yeah. I know. So it's a fair trial provision, right?
Yes, sir, the fair trial provision, that's in section 18.
But I thought that you gave a very good answer, which also implicates this point a little earlier. Now, let us stop for a moment dealing with high abstractions and deal with this case. If Mr. E.S.A. Fields had gone into the witness box and had said, as he did, "I don't know anybody called Lama," and then was confronted by the fact that he knows Lama because he told the police about Lama, Rico Hines. But he had also said that there was a man who came up in a car, who jumped out the car, shot the deceased twice, and then sped away. Now, if this Canterbury rule applies, And the judge has to tell the jury, well, you see, Mr. E.S.A. Fields, who was so drunk he told the police that his name was the name of a rum, and who was so untruthful that he denied he knew Lama until he was confronted with a statement where he told the police what Lama did and what Lama didn't do and where Lama was. That man, you have to reject all his evidence, including the evidence that he saw someone drive up in a car and shoot the deceased. How is that rule tenable? So this is why I'm saying that the answer that you gave about fairness, about, I wrote it down, that it impermissibly gives the trial judge the authority to compromise the jury's assessment of the facts, all speak to the fraught nature of this rule of law. It's all good and well for Mr. Pilgrim or any other defense counsel to advocate for this rule when you want to throw out all the evidence, because all the evidence is against the accused. I don't think they would be advocating for the rule if some of the evidence which is to be thrown out is evidence that actually is pointing towards the innocence of the accused.
I am in full agreement with that proposition, Your Honor. I cannot see a position existing where evidence given which is favorable to the accused man. I cannot see a position where the defense will want that thrown out. I can see a position where if that direction were to be given, the defense would very well have that as a ground of appeal. That vital evidence which went or which tended to the innocence or to the acquittal of the accused man, that evidence, because the direction in Scantlebury says that, well, you know, it discard everything that the witness says, then I can see where that would be the first ground of appeal in any submissions made in relation to conviction.
Would you say, oh, sorry,
Please.
would you say that it's clearly against the idea of fairness?
That runs counter to fairness.
Yeah.
Because
would you also say
that runs counter.
Yes, please.
Sorry?
Please answer.
Certainly that example would, to my mind, that would run counter to any notion of fairness.
And,
Fairness,
and would you also say it's clearly against common sense? I think you mentioned common sense.
yes, Your Honor.
So
It's
why?
not compatible,
So why?
not compatible with common sense or with justice.
So if it is so clear, then why only now have you come to this discovery? Because you said it is only recently that you changed your mind. But this seems to be going on for a long time in Barbados. So if it is so clearly against fairness and common sense, I just wonder, why is it only now that this has been discovered?
You know, Your Honor, even though I was in the law enforcement system all my life, it is only, I would say recently, from May the 1st, 2017, that I joined this department. So I have had a different view of the judicial system. Initially, I was frontline enforcement police officer. So I wasn't looking at, obviously, cases as it relates to directions given, etc. It is only within the last year or so that this direction has come to the fore. So therefore, I've had no cognizance of it before. I'm only now getting to look at it.
To be clear, I didn't want to personalize this to you, but apparently the prosecution as a whole has never really protested against it. So that's why I'm kind of surprised. I don't want to pin it on you because I understand that you are recently in this métier, but it is a fact that nobody really in the prosecution seems to have made a point of it. Is that correct?
That is absolutely correct. And I imagine that it never arose before. I think that it has arisen within the last 2 years, within the last two years or so, because as I look through a number of records, a number of appeals since I've been at this department, I haven't seen it as a ground of appeal. I haven't seen it surfacing. Only within the last 2 years that it has come about.
Two small points, if I may, please, Mr. Watson. When we spoke earlier about the recourse to the Constitution, and you mentioned quite appropriately the concept of fairness, of course, that's in the context of the right to a fair trial, fair hearing, and that's Section 18 of the Constitution of Barbados. If any person is charged with a criminal offense, and then unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. So I take it that that is the provision in which you will find some comfort, some refuge. Yes?
Yes, Your Honor.
Okay.
I'm eternally grateful for that.
The other point is a matter of clarification. If we were minded to be with you on your submission, how would you say we should treat with evidence by the accused, whether from the dock unsworn or from the witness box?
I believe, sir, that we should still keep the fairness note, the fairness tone. Continue to give the direction that judge the evidence by the same fair standards. That is the standard direction. Judge the evidence by the same fair standards that you have judged all the other witnesses. If the Lucas direction arises, I agree that we should continue with the Lucas direction. If it arises.
Sorry, so there will be no difference at all then in the directions given as respect witnesses for the prosecution and witnesses for the defense and evidence by the accused. In every case, the direction would be the same. Is that what you're saying?
Yes, the direction will be the same for all witnesses across the board. And where the accused man gives evidence, direction, judge his evidence by the same fair standards as you would judge all the other witnesses.
Okay, thank you.
Oblige you, Your Honor.
Anything else you're going to urge on us, sir?
Don't feel compelled, counsel.
No, Your Honor. I've conferred with my learned friend, and I don't think there's anything else that I would wish to add.
I'm sure that Mr. Pilgrim would love to take advantage of any time you have left.
that's it. That's it, Mr. Watson?
Yes, Your Honor.
Yeah? Okay, thank you very much. Mr. Pilgrim?
Right.
I don't propose to hog too much of what may be a little time remaining. I think that most of what is to be canvassed has been canvassed. But I think it's important to note, I don't think it assists me in any way particularly, but in both the cases, Foster and Cumberbatch, which should be in Your Honor's bundles, the DPP was taking the position that this direction was wrong, and the court disagreed with them then.
What direction was wrong?
The direction that we complain about here. Foster is 2004, and Cumberbatch is also 2004. But they're in your lordship's bundle. The other small point is not, it's just a reminder really that in the, sorry,
Can you,
point you to it, sir?
no, just to rehash in your own words, what is the direction that was given in Foster and in Cumberbatch that the Court of Appeal disapproved of?
It's quite short, Millett, so I'll just read from Foster. This is under a caption ground 3. At page 348, this direction was given. If you find that a witness is deliberately lying on oath, well, then you may disregard the evidence of that witness completely, and may is in large print. Because a witness who lies on oath in one matter is quite capable of lying on any other matter, so you may find that witness wholly unreliable. Counsel's submission is that when a witness is found to be lying on oath, his evidence must be totally rejected for the reasons given by the trial judge. A trier of fact has no discretion in these circumstances. The Director of Public Prosecutions conceded that the direction could not be supported. We also agree that the direction was erroneous, and we note that this is not the first appeal in which we have had to draw attention to the same error in respect of this direction. So the point is,
Direction ought to have been that you must disregard.
yes, so
Yeah.
the state, I'm just saying that state had taken this position before in Foster and in Cumberbatch, and the court disagreed and said Scantlebury is the position. I think it just emphasizes that it's not me making it up, really. But the only other little point I wanted to make for the benefit of the court is that in the context of Barbados, as the court is very much aware, we still cling to our unsworn statement. So in practice, this direction really goes straight to defense and prosecution witnesses who are on oath before the court. It doesn't really affect, in most cases, the accused, because typically he's remaining in the dock. That's all I wanted to add. I'm obliged. Sorry.
But, so you have never had a case where a prosecution witness who gave evidence which in some respects supported some aspect of the defense's case, but in other aspects was found to be deliberately misleading the court? You don't recall having any such case?
I would have to say it must have happened. It must have happened.
I would imagine so too.
But it applies to, the point is it applies to witnesses on both sides. So from that point of view, at least, it's not a question, in my view, of fairness. In other words, if that happens through a defense witness, many times you call a defense witness, I can think of many occasions where they go off on some tangent and say things that are completely unhelpful, and then they also appear to be false. And I think that they are all affected by the same direction on both sides.
Mr. Watson, are you still there? Oh,
Yeah.
okay. Yes.
Yes, Your Honor.
So it's even-handed as far as you're concerned, because it applies
It's
to
even-handed in that sense, in that
Both
this
sets of
applies to
witnesses.
everyone. This doesn't just apply to, it's not like we are trying to imagine some direction that only affects the prosecution, and the prosecution is being unfaired in that sense. It's a direction given to everyone.
Yes, but
It's just, but that doesn't address the fact that one particular witness in any given case maybe giving something that's important and unique, and therefore the jury ought to treat to it in a particular way.
Yeah, but if we place it against the background which you set, the, well, very minimalistic way investigations are done, very minimal evidence that you usually see, then against that background you said, well, this rule may have been have emerged, but if it takes away evidence that could help and which might be true, then that that doesn't sound to square with the idea of this absolute way of formulating the rule.
I'm guided, Your Honor. Again, one keeps returning to what you do on a daily basis. In practice, me speaking for my one part, as we say in Barbados, I seldom call many defense witnesses tactically, so that while the rule applies across the board, I keep myself out of that fire where it is possible. But again, it's not my trial.
Yeah, okay.
I think that might need to be changed, Mr. Pilgrim.
Sorry, Your Honor?
Perhaps it's a tactic that might need to be changed. If we're going to move away from the minimalistic way of proceeding, then surely relevant evidence ought to be called by both sides so we can decide the truth of the matter.
Absolutely, Your Honor. But when perhaps we have cogent prosecutions, we'll cross that bridge. In the interim, I don't think we need to cross it. You know, you're not fighting any science. You're just fighting one witness and maybe some police, and it's really comes down to who you believe. So the challenge for us has always been, and in the immediate future will always be, that you leave a case saying, I don't know if I believe the drunken man or not.
You see, the problem is it ought not simply be about who you believe. It must also be about what you believe. And a witness can simultaneously be telling truths and be telling lies. And our system of justice reposes in the jury, for better or for worse, the responsibility, the authority to pick out, to assess whether this part is a lie, in which case I must reject it, and this part is the truth, in which case I must embrace it. But from the point in time when you move towards a system where it's who you believe, and so even if the witness tells 98% of what the jury considers to be truthful, and 2% rank lies, you then discard all the 98% because the test, the frame in which we ask the jury to operate is premised solely on the person rather than the evidence that the person gives. That's the difficulty I have with Scantlebury.
I fully understand, Your Honor. The only challenge is, the only part of your formulation that I disagree with is when you move. Because we're not moving. This is what we had all along, as my friend concedes.
Yeah, well, you see, no final court has ever pronounced on whether that is movement along the right direction. And so all the discussion and arguments we're having about stare decisis, frankly, I don't know how relevant they are. Because the purpose, as Justice Anderson pointed out, the purpose for which this appeal landed here is precisely to enable this court to assess whether that movement, that direction, is one which ought to be sustained, irrespective of how long it has been going on. If it is one which is in contradiction to other fundamental rules of law, and has never been sanctioned by a final court before, the issues of stare decisis simply do not apply, in my respectful view.
Your Honor, one can't help feeling from a tactical perspective that I should have agreed with the court at the leave stage when they were telling me I had no right coming with this foolishness at all. I should have kept my mouth quiet.
Occur to me, Mr.
I'm sure that it did, Your Honor. I have No doubt.
And I thought that the generosity of spirit and in the best forensic tradition, you decided to do the right thing.
Your Honor, there is, I think the challenge to taking the former position is this. Barbados has now 7, I think my friends will correct me if I'm wrong, 7 judges for the first time sitting in the criminal jurisdiction, which is a tremendous advance from where we were with 2. And a lot of other things are actually working in Barbados. I think I have a duty to say that to you because I have been here casting mud. So a lot is happening. And the challenge is that, and Mr. Watson will bear me out because he works in this court with Justice Graves constantly. Justice Graves is taking this position. And I have no doubt he may be vindicated in that to some extent, because I still think there would need to be some tailoring of what he is doing. But he's taking that position. And even judges who were prosecutors in Graves, for example, and the 2 I mentioned just now, and were fighting against that position, are still giving the Scantlebury. So that it would be fairly disingenuous of me to say this point did not need to be resolved as a matter of urgency.
Absolutely, and that's why you have a final court. Or otherwise, you then encourage cherry picking. You then encourage, what's it called, forum shopping, you know, and yeah. So
A practice which I myself, sir, loathe to engage.
Yeah. We believe you.
I'm
Thank
obliged.
you very much
I'm
for your
obliged, Your Honor.
submissions, Mr. Pilgrim. Thank you, Mr. Watson, and we'll take time for our decision in this matter and let you know.
Obliged.
I'm obliged, Your Honors.
All rise.